representative.
And my name is Nur Adriana Raisa, and I play as the role Miss Lisa.
Just have a seat. Good afternoon. Just have a seat. I understand that both parties are here because of the accident that happened on the renovation site, and it involving scaffolding work, right?
Yes, I made an appointment because I was seriously injured, and I want legal advice whether I can claim compensation.
So, I am Tanya. I'm here representing Pro-Build Syndrome. We also ready to explain our side of the matters.
Very well. Ms. Lisa, please explain exactly what happened from the beginning.
On 20 September 2020, I was walking along a public road beside a luxury apartment building owned by elite residents in Bahad. The building was undergoing renovation works carried out by Pro-Build Syndrome Bahad. While I was passing by, a scaffolding platform on the third floor suddenly collapsed. I heard a loud noise, and before I could react, tools from above and a heavy hammer struck my arm.
That must have been very sudden. So, what happened immediately after?
I felt severe pain, and I could not move my arm. And the people around me called an ambulance, and I was taken to a hospital.
So, Miss Lisa, what is your occupation?
I am a professional pianist. After medical examination, my doctor told me there is a risk that I may not regain full function of my arm, which could affect my career permanently.
I understand. That is a very serious consequence. Based on your explanation, the situation may fall under the law of negligence. To succeed, we must establish 4 essential elements. First is duty of care, second is breach of duty, and the third one is causation, and the fourth one is damage. Without proving all 4, a negligence claim cannot succeed.
We acknowledge the legal test, but we maintain that safety procedures were implemented on site.
That we considered. Let us analyze the fact carefully.
So, what exactly is duty of care in this situation?
Duty of care is a legal obligation to take reasonable steps to avoid causing harm to others.
We will carry out construction works under a contract with elite residents, and safety measures were in place for workers.
However, as a construction company operating in a public area, Probate also owed a duty of care to members of the public passing by the site.
So, even the people walking outside the building are protected?
Yes, it is clearly foreseeable that construction activities involving scaffolding and tools at height could pose danger to pedestrians below.
We do not dispute that a duty of care exists toward the public.
Good. So the first element is satisfied.
Then, where did things go wrong?
The issue is whether Probate acted as a reasonable contractor would in the circumstances. Here, a scaffolding platform collapsed during ongoing work. A reasonable contractor is expected to ensure scaffolding is properly erected, secured, inspected regularly, and safe for use.
Construction work is inherently risky. Even the precaution expects that failure can occur.
That is true, but scaffolding systems are designed to be safe when properly maintained. A sudden collapse suggests that there may have been a failure in inspection, maintenance, or installation.
So, the accident itself suggests negligence?
It is strong evidence of breach of duty, so yes.
How do we prove that Pro-Build actually caused my injury?
We applied the but-for test, but for the collapse of the scaffolding, the hammer would not have fallen.
But the hammer was what physically caused the injury.
Correct, but the hammer did not fall on its own. It fell because the scaffolding failed. So, the collapse is directly in the chain of events leading to Miss Lisa's injury.
So, the accident started from the unsafe scaffolding?
Exactly. There is clear factual and legal causation.
What kind of compensation can I claim?
You suffered a broken arm, significant pain, and emotional distress. More importantly, as a pianist, your injury affects your earning capacity. So, you may claim medical expenses, pain and suffering, loss of income for past and future, loss of future earning capacity, rehabilitation, and therapy costs.
My career depends on my hand. This is very worrying.
That is why courts take such injuries seriously, especially when they affect professional ability.
That could lead to substantial damage.
Yes, depending on medical reports and financial evidence.
We have placed a notice at the site stating that probably accept new liability for any injury, death, or damage during the renovation works.
I did not see any such notice before the accident.
Even if the notice existed, it is unlikely to protect Probuild. Mrs. Sa did not consent to it, and liability for negligence toward the public cannot simply be excluded by a sign.
I understand your point.
In that case, can I sue the building owner, Elite Residence?
Generally, Elite Residence hire Probuild as an independent contractor. In most cases, the contractor is responsible for negligence arising from its own work, unless Elite Residence were directly involved in supervising or controlling the work. Liability is more likely to rest in Probuild.
Fully responsible for the renovation works.
That supports the conclusion that Probuild is the primary party liable.
So I have a strong negligence case?
Yes, all four elements of negligence are clearly present. You have strong claims against Probuild Sdn Bhd.
Thank you, lawyer. I just want fair compensation for what happened to me.
We will proceed with preparing your claim and gathering all supporting evidence.